Well, as you heard from Justice Caricia's decision, she was satisfied beyond a reasonable doubt that the Crown proved Mr. Bertrand participated in the activities of a terrorist group, which was the Adam Waffen Division, also known as the National Socialist Order, by applying to join the group and offering skills and expertise to facilitate or participate in terrorist activities of the group.
Interesting that the criminal code doesn't require that he did anything for them. It was enough to apply and to say, I have skills X, Y, and Z.
That's right. As Justice Caricia noted, the criminal code specifically provides that it's not necessary that the activity actually be carried out or that he knows the specific activity that will ultimately be carried out.
What kind of precedent is this, if any? Like, have we seen these types of convictions? Like, how many have we seen in Canada?
Well, unfortunately, it's not the first time somebody's been convicted of this offense under the criminal code.
Would say going into this, I was as uncertain as has ever been on any matter. It was a truly novel legal situation. You know, it's not offensive to say I disagree, but I made my argument for a reason. But Her Honour's reasons were fair and well reasoned, and we accept them.
What did Mr. Bertrand say? How did he react?
I mean, I would say fairly flat. You know, this is it's an unusual situation where I know as counsel, and Mr. Bertrand knows as a person, that he committed a moral wrong. We didn't hide from that. We agreed with everything he did. We didn't challenge any evidence. He didn't instruct me to do so. We know what he did was morally wrong. This was a legal question as to whether or not it was caught as criminal conduct. So, you know, as obviously any person with the instinct of self-preservation would rather be found not guilty than guilty. You know, it's not as though he feels cheated or unfair because, as I said, we knew what he did. It really was an academic question. He's accepted what he's done. He's accepted responsibility for what he's done. It really was an academic argument. So obviously he's disappointed to a degree that he was convicted and that this will continue to hang over his head and that there's the possibility of incarceration. But, you know, there's no shock here. There's no feeling like you weren't heard, or there's no feeling like the judge got facts wrong. It is an interpretation of the law, and it's a novel area of the law. You know, the Crown attorneys on this case, who have been very fair, said that at the outset. I said that at the outset. It really is truly a novel case. So I don't practice appellate law, but this did feel a lot like an appeal where we were dealing with more or less a factual vacuum, and it was up to the judge to interpret it.